Know your rights as an individual, especially if you want to achieve divorce. If the person involved is refusing to sign any paper or acknowledge or receive a letter from the courts, there are so many ways you can achieve divorce without even the person being present in the courts. This video is very long, but you have to take your time, pay attention, listen to it, then share. Watch this
It's sort
barrister
of
and hear what
created
he
the
has to say.
impression that the man needs to sign the divorce in order for the woman to have a divorce. So many of you thought so. And I asked myself, why do they believe that the man has to sign the divorce in order for there to be a divorce? In other words, it implied that the man has to give his permission in order for the woman to be divorced. That is, if the man doesn't sign, then the woman wouldn't get it. That picture is wrong. But I know where you got it. You got it from the movies. In many movies you've watched, you will hear a man say to his wife, or the wife say to the man, I will never give you a divorce. I will never give you a divorce. I will never sign a divorce. So from there, many people assumed that you cannot divorce your spouse unless your spouse signs or agrees to divorce. That's not true. That's no longer true. In the past, many decades ago, or even centuries ago, divorce was not allowed. There was restriction on divorce. It was difficult to divorce anybody because in those days, the churches were in control of divorce. And even till today, the Catholic Church doesn't allow divorce. Instead, they turn around and call it annulment. So if you want to break a marriage under the Catholic law, they will not see it as divorcing. They will treat it as annulment. That is, they assume that the marriage never existed. Annulment is what happens where the marriage never existed or were never proper. So, because of this old attitude against divorce, there were all kinds of obstacles placed on the way of somebody trying to get divorced. And one such obstacle was that they required the person you want to divorce to agree to divorce. And based on that old tradition, when you watch movies today, you will still hear somebody say, I will never give you a divorce. I will never give you a divorce. Or you say, okay, go and get the divorce, I will sign it. Go and get the divorce paper, I will sign it. But it's not true. You don't need the permission of the person you want to divorce in order to divorce him. In fact, he has nothing to sign. The person you want to divorce has absolutely nothing, cannot sign the divorce. The court will divorce you even if you don't agree. The court will divorce you even if you don't show up in court. The court will divorce you even if you don't respond, provided that the person who sued you for divorce has met the requirement of law. Many women come to us and say, oh, I don't know his address. He will not come to court. So that means I can't divorce him. I say, no. If he doesn't come to court, if he doesn't respond, it makes it easier for us to divorce him. Absolutely. If you don't show up, if you don't respond, then divorcing you becomes very easy, because what the court will do is to move the case from contested divorce to uncontested divorce. In other words, your absence or failure to participate will make the divorce easier because there's no challenge to the divorce. The court will grant it easily. What I believe caused confusion in this particular case, when people are saying sign divorce, let me tell you how the confusion arose, how that issue of signing came up. You know, before the court, there are two types of authority the court has. We call it jurisdiction. There is the subject matter jurisdiction and there is the personal jurisdiction. Subject matter jurisdiction is the power of the court to hear that type of case, to hear the particular type of controversy. For instance, it is only the High Court in Nigeria, State High Court in Nigeria, that has the jurisdiction to hear divorce cases if the marriage was under the Marriage Act or statutory marriage. So you cannot take your divorce case to a magistrate court. Magistrate court has no jurisdiction to hear divorce cases. If the marriage is customary law marriage, then only the customary court has jurisdiction to hear that controversy. So we call it subject matter jurisdiction, because the courts are divided in such a way that some courts hear certain type of cases but not others. Some courts hear certain type of cases but not others. So when a court can hear all manner of cases, we call it court of general jurisdiction. But those courts are very rare these days because courts are confined. There are some cases that cannot go to High Court, you must go to Magistrate Court. There are some cases that can go to both, so you have to choose. So we call it subject matter jurisdiction, the power of the court to hear a particular type of case, subject matter jurisdiction. Then the second type of jurisdiction is called jurisdiction over the individuals, over the parties. The power of the court to make orders against a particular individual, the court must have a jurisdiction over that individual. So, in addition to having power to hear a particular type of case, the court must also have the power to hear that particular type of case in respect of these particular individuals. Subject matter jurisdiction is decided by law, the statute. For instance, the Matrimonial Causes Act, which is the procedural law governing divorce, separation, annulment, if the marriage is under the Marriage Act in Nigeria, that act, Matrimonial Causes Act, gave the subject matter jurisdiction to State High Court. Because in State High Court, you cannot take it to Federal High Court. Federal High Court has no subject matter jurisdiction over divorce cases. So a lawyer will first determine which court has the right subject matter jurisdiction. Absolutely. Then you will also look to see if there are what we call territorial jurisdiction or forum jurisdiction. I'll give you an example. If you have a contract in Lagos State and you have a dispute over that contract which was formed in Lagos State, you cannot go to Ogun State or Imo State High Court. It has to be in Lagos because it is territorial. That particular controversy, contractual disputes are territorial in addition to subject matter. However, interestingly, when it comes to marriage issues under the Marriage Act of Nigeria, all the state high courts have jurisdiction. So even if you married in Lagos, your husband can file for divorce in Maiduguri, in Borno State. Of course, that will be a problem. When you live in Lagos with your husband and he goes and files in Maiduguri, Maiduguri will have subject matter jurisdiction. It will also have jurisdiction over venue because the law gave the entire country, turned the entire country into the same forum. So, but now let's go to the personal jurisdiction. We call it in the Latin term, its original term, jurisdiction in personam. Jurisdiction in personam, which means the court has jurisdiction over the particular individual. How does the court acquire jurisdiction over an individual? The court will serve you what we call summons. Summons. That is, it is a notice for you to appear in court. If it is a civil summons, It's up to you to come or not to come. But if you don't come, there will be consequences. If it is a criminal summons, you must come. Because if you don't come in criminal summons, bench warrant will be issued against you, or arrest warrant will be issued against you for you to be arrested. But in a civil matter like divorce, which is a civil matter, no, you will not be arrested. So, but for the court to get jurisdiction over you, they will serve you summons. And for the summons to meet the requirement of due process in accordance with the Constitution, the summons must contain the following. It must contain the notice that a petition has been filed against you, asking you to come if you wish to defend it, or to file an answer if you wish to do so, and warning you that if you don't file an answer, the case will proceed without you. That is the summons. But because due process requires that a person who has been sued in court should know the reason why he's sued, he must know the allegations against him. And that is then when you file the petition itself. The divorce petition contains the allegations, contains the facts of the case. Now, another due process requirement is that the person you sued must have adequate opportunity to respond. To give him adequate opportunity to respond, the court will give him 28 days to respond to the petition served on him. So, in the normal circumstances, the court bailiff will come to your address, the address that is written on the petition, and give you the summons containing the petition. We call it serving you the process of court. The essence of serving you that document is to give the court jurisdiction over you. Once you are served that document, the court now has the power to make orders against you. Without you being served this thing, the court cannot make orders against you, except in very rare cases, what we call ex parte proceedings, emergency law. That is something else we discuss some other time. But when they serve you the summons, you can take the summons and acknowledge that you received it. That is when you sign. I, so and so man, received a copy of the summons on so and so date signed. When you sign it and give it, because the bailiff will come with 2 copies. They serve you the original, they give you one to acknowledge that you received the original. Now, when they give it to you, you can be a gentleman and take it and sign it, and there's no problem. In fact, before they come to your house, some people live in gated community. So, if you sign it, there's no problem. You're signing acknowledgement of receipt, not the divorce, not the divorce. You are signing an acknowledgement that you received a copy of the divorce petition, together with the summons of the court. In that particular case that you people know, which is where you got this idea, we are here, sign the divorce. They came to serve the summons on the man and his girlfriend. They came to serve them summons. The bailiff called them on the phone because your number is stated there. They said, hey, I'm bailiff, I am from Lagos High Court, I've come to serve you papers. A gentleman will say, okay, this is where I am coming to my place. So, but this particular man began to lie. He said, where are you? He said, well, I am at so estate. He said, no, I don't live there. I'm not there. He didn't know that the bailiff already asked the gate man. If they saw him, they said, yes, he lives here, he is there. So when he began to tell the bailiff that I don't live there, then he told the gate man to say that he was not there, that they don't live there. So that was why the bailiff began to chase them around, trying to get them to accept the summons and sign it. So it became a concern that these guys are running, they don't want to sign an acknowledgement. But, so, what happens if you don't sign? Will you be able to block the divorce by not signing? No. You just delay it by 1 month to 2 months. Because this is what we will do. When they try to serve you that document and you're dodging and lying and hiding, the bailiff will call the lawyers and say, hey, this guy has been evading me. I've been in Enugu for 2 days trying to serve him, and he's not taking it. What do? I think, I should come back. We say, yes, come back and prepare affidavit of non-service, affidavit of attempted service. Because when the bailiff comes back, if you sign that acknowledgement letter, acknowledgement that you got this, bailiff will prepare a brief affidavit of service. He will say, I, so person, a bailiff of this court, hereby swear and state that on so date, I went to the address of so man, the defendant in this case. I served him a copy of the summons, and he acknowledged it as seen in the attached acknowledgement. He will attach it. So they'll put it in court. So when the court looks at it, the court will say, yes, the man has been served. So he knows that this case is on. Therefore, I have jurisdiction to proceed. Now, if you refuse to sign that thing, forgive me, I laugh because a lot of people think they're smart. If you refuse to sign that acknowledgement, the bailiff will come with an affidavit. The same affidavit, but the language will be different. On so date, at so time, I arrived at the address of this person with intention to serve him the process of court. I spoke to him on the phone, and he told us he's not living there, but the gateman told us he was living there. That on the next day I came back, and the man ran away. That I did everything, but I couldn't find him. As a result of this, I wasn't able to serve. That is what his affidavit will show, that he tried to serve. Then we go back to court. We file what we call application for substituted service. Substituted service. Because you see, the law first say we should serve you directly. That's this thing. But when we cannot serve you directly, we serve you by substituted means. We say, my Lord, we refer to the affidavit of non-service attached by the bailiff, indicating that he made effort to serve, but was frustrated and was not able to serve. On the basis of that, we hereby request the court to grant us permission to serve him by substituted means, viz. By email at this email address, by WhatsApp at this WhatsApp number, or be allowed to paste it at his gate, or be allowed to publish it in the newspapers, or be allowed to post it on the notice board of the court. The judge will look at it. The judge will see that there was an attempt to serve him papers, and he didn't take the papers. He rejected the papers. He ran away. He lied. And the court will say, based on the affidavit of the bailiff and based on the application of counsel, I hereby grant permission for service to be effected by WhatsApp, email, or whatever. And once the court does that, we thank the court, we get a copy of that ruling, we attach it together with the thing and send it by email or by WhatsApp. And then the same bailiff will do it. And the bailiff will now prepare another affidavit. Pursuant to all court orders, so and so, I served this thing by sending it to his email, and I believe he received it. The court now has personal jurisdiction over that man. The court will move forward. When the 28 days passes, if the man doesn't file any response, the court will ask the petitioner's lawyer to set the case for undefended list. that is uncontested divorce. And they will set it for uncontested. On the trial date, the petitioner will come and testify. Given that the defendant is not responding, the respondent is not responding at all, the court will ask for written address in preparation for judgment, and the court will give judgment. So, please, I want you to understand that you don't need the signature of the person you want to divorce in order to divorce him. You don't need his permission in order to divorce him. All these things they do in the traditional setting. I say, I will not take back the bride price and use that to delay you. It doesn't happen in reality, unless you don't have a good lawyer. There's always something to do. We know what to do. We know what to do.